right, we're going to get started here in just a minute. We're going to wait a little bit longer for some last-minute additions, but if you're here for the expungement training, you are in the right place. Okay, we're going to go ahead and get started here. My name is Matthew Stubenberg. I'm the IT director and a staff attorney at the Maryland Volunteer Lawyers Service, and I run the expungement department here. And before we get started, I've added a number of handouts to the webinar. They include a couple of flow charts, incarcerable traffic offenses, some things I'll talk about during the presentation. So they should be in the handout section of whichever kind of webinar interface you're looking at. If you can't find it, don't worry too much. I'm going to send around an email after this with these same attachments. This PowerPoint is available online, and it'll be available after this presentation, and so there's no need to furiously copy word for word everything in this PowerPoint. You can always go to the link, which will have this PowerPoint loaded up, and it is located at the link right here that I've put into the chat box. So you should have seen that pop up. So if you take a look at the chat box, you'll see the link for this PowerPoint that should work after this. If you have any questions, everybody is muted by default. The best way to ask a question is to either type it into the chat box, or you should have a question box there where you can type in a question, and I encourage everyone to do that. Some of this stuff is very complicated, especially if you're coming in brand new to expungement law. So please feel free to raise your hand, ask questions, and add comments. If for some reason, the audio cuts out or something like that, just write in the chat box, or if it's not coming over loud enough, just let me know and I can try to fix that. Okay, so we're going to go ahead and get started here. It's 12:02. So this is going to be a complete overview of expungement law. It's going to cover the old expungement law that's still currently active. It's also going to cover the new JRA changes that have come into effect since October 1st. When we come to those new changes, I'm going to specifically call them out. So if you're already familiar with expungement law and you primarily want to learn about the new expungement law that just came into effect in October, I'm going to point those pieces out as we go through them. Okay, so let's briefly just start here with why expungement. Right, I think we all have probably a pretty good sense of why expungement helps, but having a criminal record can really hold somebody back in a number of areas in their life. It holds them back in employment, in housing, education. It can even affect their credit. And then even on a more generic basis, it can affect social circles. If you're nervous about volunteering for something because you're worried that somebody is going to see your criminal record, you're going to be less likely to volunteer and interact with your community. So generally, expungement is the removal of Maryland criminal cases from a person's criminal record. So I bolded Maryland and criminal. So this only applies to Maryland cases, not Virginia cases, not DC cases, not federal cases, only Maryland cases. And it only applies to criminal cases. Now technically it's criminal cases, citations, and some incarcerable traffic offenses. But it all falls into that criminal category. We can't expunge foreclosures. We can't expunge, divorce cases or tort cases. It's only criminal cases. So how bad is the problem? So here's some statistics on it. 60% of all Baltimore City District Court cases were eligible for expungement in fiscal year 2015. We have to go fiscal year because that's how the courts report their numbers. And out of about 23,000 cases that were eligible that year, only about 8,000 petitions were filed. So for many years, we've been building up this backlog of cases that are perfectly eligible for expungement. I am happy to report that in recent years, we have been able to catch back up, and we've started expunging about as many cases as we produce. But there's still a very big backlog. The last count was done in 2014, and there were at least 1 million eligible cases for expungement in Baltimore City alone. So what does 1 million cases in Baltimore City kind of look like? So this is only from the year 2015, and this is just a small cross-section of Baltimore City. Each one of these pins represents a case that's eligible for expungement. And so the problem is very wide and very vast, and affects almost every part of Baltimore City and every part of Maryland, which is why we need as many pro bono attorneys as we can to help expunge these cases, as many community organizers to understand the law so they can funnel people who have eligible cases to us. It's really going to take the whole community here in order to make a dent in this problem. Okay, so let's go over what the law is. So the law is primarily contained in Maryland Criminal Procedure 10-105 and Maryland Criminal Procedure 10-110. And the second one, 10-110, is the new provision added by the Justice Reinvestment Act, which is the new law that came into effect October 1st. So generally how these laws are separated is 10-105 covers situations where there's a non-conviction, something other than a conviction. Things like null pros, debts, PBJs, which I'll go over all of that. There are a few exceptions to that. There are 2 conviction types that are eligible in 10-105, but the vast majority of cases that are eligible when there's a conviction involved is going to be covered under 10-110. So that's generally how they're split up. So I'm going to talk about non-convictions, which non-convictions are eligible, some of the caveats in filing depending on what the disposition is. Then I'm going to talk about which convictions are eligible. And then there's some other kind of procedural aspects to this I'm going to cover. So first, let's talk non-convictions. So the general rule is if you did not receive any convictions in a case, then your case is likely eligible for expungement. So that's the general rule. If there's not a single guilty, odds are you can get it expunged. And what is a non-conviction? Well, it's anything other than a guilty. And that includes a nolle proseque or a null pros, a not guilty or an acquittal. And a null pros is when the state declines to prosecute. A not guilty or an acquittal is when a judge or a jury found that there wasn't evidence beyond a reasonable doubt. Dismissal, the court threw it out for some other reason. A transfer to juvenile court. For these, if you're under the age of 18 but you commit certain heinous crimes, you start out in adult court and then you have to ask the court to send you to juvenile court. If you're successful, your disposition, your verdict for your adult case, it's transferred to juvenile court. And the fact that you were ever in adult court can be expunged regardless of how things turned out in juvenile court. There's a stet disposition, and a stet is kind of a complicated disposition, but it's kind of like a purgatory for criminal cases. Criminal cases get placed on the stet docket. In theory, they can come off and be retried, but there's so many cases, especially in Baltimore City, that very few cases ever do. Then finally, we have a probation before judgment. Probation before judgment is commonly used as kind of a get-out-of-jail-free card for your first offense in something minor. So this is your first time in on a petty drug possession charge. Odds are you'll get a probation before judgment, and a probation before judgment does not count as a conviction. Okay, so let's talk about these in a little bit more depth. So, as you'll notice, what the disposition is usually what's controlling for whether or not your case is eligible for expungement. Especially in this non-conviction category, what you were charged with isn't all that important. It's what you received on your verdict or your disposition. And so I'm going to cover these in a little bit more detail here, and these all fall into one category of kind of the best dispositions, right? This is where your client went in, they beat the charge. The state dropped it, they went to trial, they won, or they got transferred to juvenile court. All those count as a win. These are all eligible for expungement immediately after the disposition is given. If you're filing within 3 years of the disposition date, the state also makes you give up your right to sue them, them being the state, for anything related to that case. And the reason they make you do that is when you get your case expunged, they'll actually destroy or shred your file. And what they don't want you to do is immediately get it expunged, then turn around and say, hey, when you put the handcuffs on, you put them on too tight, it broke my wrist, and now I want $1,000 in medical damages. They can't defend themselves because they've already destroyed all the evidence related to that. So what they do is they make you give up your right to sue. They say you can either get this expunged or you can sue us. You can't do both. Now you'll notice that we didn't actually talk about what the person was charged with. It doesn't matter what they're charged with for this disposition, for this group of dispositions. It could be they're charged with murder and they received a null pros or they're found not guilty. It could be petty possession of marijuana. It can be theft. If they're found not guilty, they get a null pros, dismissal, or transfer to juvenile court, you can get that expunged immediately. So here we have somebody who was charged with fraud, conversion of leased goods, and this is just a screenshot from Maryland Judiciary Case Search. Hopefully everyone has used Case Search. It's by far the best and easiest way to get information about somebody's criminal record, although it does have its drawbacks. But if we take a look, at the disposition, this person received a nolle prosequi and received it in 1999. So without even looking at what they were charged with, this case, we know this case is eligible for expungement. There's only one charge. It received a null pros. We know it's eligible. We take a look at the date just to see if we have to file that additional paperwork for them to give up their right to sue, which I'll talk about later. This is from 1999. We're outside that 3-year window. The statute of limitations almost certainly has run on anything from this incident. And so they don't have to give up the right to sue because they've waited so long that they've kind of de facto given up their right to sue. So this case would be eligible for expungement. Any questions about that? All right, and all my examples today are going to be if are single charge cases or all the charges receive the same disposition. That's how I usually do it when I talk about the law, and then I'll go over what happens if you have multiple charges with different dispositions, where you're found guilty on one and not guilty on another and instead on another. But for right now, it's just single dispositions. So here we have an assault second degree case. So with stet dispositions, it falls into its own category. A stet is not really a win, but it's not a loss either. It's kind of a middle gray area. And a stet disposition is kind of complicated, but it's unnecessary for the expungement purposes to go into exactly what a stet docket is or how it works. But if your client receives a stet disposition, they are eligible to get it expunged 3 years after the disposition date. So as before with the best dispositions, you could do it immediately. With a stet disposition, you have to wait 3 years before filing. And that's from the disposition date, not the incident date. So here we have somebody charged with assault second. They received a stet, and they received that in 1997. More than 3 years have passed. So this case is perfectly eligible for expungement. Okay, and if you start to get a little confused, try to follow along with the flow charts that are in the handout section. They can help you kind of follow the tree down to whether or not something's eligible for expungement or not. Okay, so here we have probation before judgment. And probation before judgment also falls into its own category. It's not a win, but it's not a loss either. And a probation before judgment, otherwise known as a PBJ, is usually eligible. Now, there's two big exceptions with PBJs. Before I go any further, I found a lot of people call PBJs PB&Js, right? Kind of the acronym for peanut butter and jelly sandwiches. You know, if you do that in court, people will laugh at you. So I encourage you to call it PBJ, not PB&J. Okay, so the general rule with probation before judgments are that they're eligible for expungement, but much like a stet disposition, you have to wait 3 years after the disposition date. And so you can't file right away. You have to wait at a minimum 3 years. Now, the two big exceptions to probation before judgment are the DUI, DWI exception, which says that if you receive a probation before judgment on a DUI or DWI, it is not eligible for expungement. It's not like it increases the waiting time. It's not like you have to file an additional form. It's just not eligible. Apparently, they thought too many people were getting DUIs, getting a PBJ, getting expunged, and then getting another DUI, and the court didn't know if they had any previous DUIs. So they made it so if you get a PBJ on a DUI or DWI, it's not eligible for expungement. And this is the first case where we actually have to look at what they're charged with. In the stats, the null process, the not guilties, it doesn't matter what they're charged with. With probation before judgment, there is this exception, so you have to take a look to see if they were charged with a DUI or DWI. The second big exception is something called the subsequent conviction rule. And this used to apply to expungement kind of rule in whole, and now only applies to probation before judgment, and then it's with some convictions that we'll talk about later. So what it says is if the person has a conviction within 3 years of a PBJ that you're trying to get expunged, that PBJ is now no longer eligible for expungement unless you can get that conviction expunged. It's the state's way of saying, look, we're giving you a PBJ, and as so long as you don't get a conviction, you don't screw up in the next 3 years, we'll let you get this PBJ off your record. If you screw up in the next 3 years, you're out of luck. It's going to be on your record forever. And so that's kind of, it can be very punitive, especially if the conviction is relatively minor, but that's what the law says. And I have some examples of this here. So first we have the DUI example. This person was charged with attempting to drive while under the influence of alcohol, and they received a probation before judgment in 2010. This case is not eligible for expungement. It will never be eligible for expungement. They will have to try to go the pardon route or try to get the disposition changed. But this case, as it stands now, will never be eligible for expungement. And keep in mind, you're taking a look at the disposition, not the plea. You can plead however you want, right? You can plead not guilty and be found guilty, or in this case, you plead guilty and receive a probation before judgment. It's the disposition that matters, not the plea. So here's an example of the subsequent conviction rule. So here we have somebody with a case. They received an assault second. They received a probation before judgment in 2009. In case number 2, the same client, they have a attempted CDS manufacturing, and CDS is controlled dangerous substance or drugs. So they attempted to sell some drugs and were found guilty of this in 2010. So as we'll learn, we haven't covered convictions yet, but this is not eligible for expungement, this second case. And because they received a conviction within 3 years of this probation before judgment, right? This is from 2009, this is from 2010. This case, case number 1, is now no longer eligible for expungement. They cannot get it expunged. If this case, this attempted manufacturing and distribution case, had come in 2013, 4 years after the assault second, then we could have gotten the assault second expunged. But unfortunately, it's a subsequent conviction within 3 years. Now, keep in mind, these are 2 totally different charges, right? Assault versus drugs. They could have happened in different counties with different victims, different times of day, the whole 9 yards. It's largely irrelevant. It's only if it's a subsequent conviction. Okay, so that's non-convictions. Before I go any further, with the probation before judgment and subsequent conviction, the subsequent conviction rule only applies to probation before judgment and then a few convictions that I'll talk about. You don't have to do that analysis if they received a null pros, a not guilty, a stat, something like that. Okay, any questions on non-convictions before I move on? Okay, so let's move on here. So convictions, this used to be a much shorter slide. It used to have basically just two exceptions, nuisance crimes and then some marijuana possession. Those still exist, but now with the new Justice Reinvestment Act, there are a lot more convictions that are eligible for expungement. So I've broken these convictions and the different caveats and exceptions that apply to them into two different main categories. Those that have a relatively short waiting period, 3 to 4 years, and those that have a relatively long waiting period, 10 to 15 years. So let's talk about the short waiting period convictions first. So the first exception, or the first, not all convictions can be expunged. It's only if the conviction falls into a certain category. And with convictions, you have to take a look at what they were charged with. That's going to determine whether or not you can get it expunged. So the first category here under short waiting period convictions, those are about 3 to 4 years, is something called the nuisance conviction exception or eligibility. So if your client was convicted of a nuisance crime, they can get that nuisance crime expunged. And so what is a nuisance crime? It's any of these ones below, or it's one of the transit violations set to the right. The most common that we see are urinating in public and failure to pay fare or exhibit proof of payment of fare. Those are by far the most common. These are eligible for expungement, but you have to wait 3 years after any sentence or probation. Now, in practice, most people don't get any probation or sentence for something like panhandling. So in practice, it's usually just 3 years after the disposition date. But you still have to wait 3 years. So you can consider nuisance crimes similar to a stet disposition. You have to wait 3 years, and then the conviction has to be one of these right here. I've included the full list of nuisance crimes as one of the handouts, if you want to take a look at it later. So this person was charged with urinating in public, received a guilty, and so this case would be eligible under the nuisance crime exception. So they were convicted of a nuisance crime. I jumped the gun here. They were convicted in 2017. So this will become eligible in 2020. So they have to wait 3 years, but otherwise this will become eligible for expungement. So this is the other category in the short waiting period marijuana, or short waiting period category, and it's pretty much marijuana possession. Basically, the state has come out and said if you were convicted of just marijuana possession, you can get that expunged. Now, the waiting period here is 4 years from the disposition date. Now, not that many people get marijuana possession charges anymore, so it's not that common to see, but there are a lot of marijuana possession cases currently in the backlog. So usually you don't have to worry about the 4-year provision because there haven't been that many given out in the last 4 years since it was decriminalized. But it does cover all marijuana possession. Now, it's only possession. It's not intent to distribute, manufacture, anything like that, and it's only marijuana. It's not heroin, cocaine, anything like that. It's only marijuana. However, the big change in the law starting October 1st is that it can be any amount of marijuana. Now presumably if they had 100 pounds of marijuana, they would have been charged and convicted of intent to manufacture and distribute or something like that. But the reason this is such big news is before October 1st, the way we would expunge marijuana convictions is under a provision called the crime no longer a crime provision in expungement law. And this is the other kind of category under short waiting period convictions that really only applies to marijuana possession. And when marijuana was decriminalized, only possession of less than 10 grams was decriminalized. So we would have to, let's say a client had a conviction for marijuana possession, we would have to go in front of the judge and try to pull the records and find that they were convicted of less than 10 grams. It was taking a very long time, and the vast majority of people are convicted of less than 10 grams. So the state finally corrected that and said, okay, all marijuana possession is eligible for expungement. You just have to wait 4 years. Now, the crime no longer a crime provision still exists. So if something becomes decriminalized in the future, people can get that expunged. There are some other exceptions, things like I think it was refusal to return a rental vehicle in the appropriate amount of time used to be a crime, is no longer a crime, but the vast majority of what we used it for was marijuana possession. So here we have somebody that was charged with CDS possession marijuana, and you can see the disposition date here, or the is 2010, and they received it guilty. So this case is eligible for expungement. It's been more than 4 years, and it's a conviction for marijuana possession. Okay, we have a question here. For the example where the person was convicted of urinating in public, does the 3 years start from the occurrence to happen latest, or the end of probation, or the earliest, the disposition date? So it's technically from the end of the, let me go back here. It's technically from the end of any probation or sentence or probation. So it looks like they may have received 60 days, perhaps. There's no probation end date, so it's a little confusing, and the jail time was suspended. And so in this case, you might have to do a little bit more research to see if it'll be March 2017 or May 27, or sorry, March 2020 or May 2020 when this will become eligible for expungement. But yes, nuisance crime is from the end of any sentence. Okay, here we have the second kind of big category of convictions. Before I go on, does anybody have any questions about nuisance crime convictions or marijuana possession? Okay. So this is the long waiting period convictions. And this is entirely the new Justice Reinvestment Act. This is the law that came into effect October 1st of this year. Now, it's good in the sense that it allows for a lot more convictions to be expunged. However, there are some caveats that can really hold people back and make it not quite as effective as we would have liked. So this is covered under the Criminal Procedure 10-110, and below is a list of all of the major convictions that apply most frequently to our clients. So they include assault second, trespass, CDS possession, paraphernalia, prostitution, gambling offenses, theft, some tax claims, some real estate stuff, and then attempt or conspiracy to do any of these as well. The actual list of convictions eligible for expungement is something like 40 or 50 items long. A lot of them have very kind of are very unique, and I've never come across people being convicted of it. Things like gambling on a boating establishment, and so I didn't include it in this list. If you're curious, I included it in the handout, the Justice Reinvestment Act expungement chart, and it's also available online under on our website /new expungible convictions. So before I go any further, I want to say that all of these convictions only apply if it was the misdemeanor version of this conviction. So for some of these charges, it can only be a misdemeanor, right? I don't think there's any felony trespass. And I'm not even sure there's felony, I don't think you have felony CDS paraphernalia. However, some of these do have a felony version, right? For theft, if you're convicted of theft of greater than a certain amount, that is a felony theft charge. You can only expunge the misdemeanor version of these charges. If they're convicted of felony theft, then you're out of luck. That's not eligible for expungement. It's only if it's misdemeanor theft. So before I go any further, CDS possession, that's all CDS possession. Heroin, prescription pills, whatever it may be, it's all CDS possession, but it's only possession. It's not intent to distribute, manufacture, anything like that. And the same with paraphernalia. That's paraphernalia for any drug. Okay, so why is this category called the long waiting periods? Because they have some very long waiting periods before you can expunge. So the first one is 10 years from 10-year waiting period. Now this applies to all of the convictions that were on the previous page, except for assault second, common law battery, and then crimes designated as domestically related. For those three convictions, assault second, common law battery, and domestically related crimes, there's a 15-year waiting period. And that's from the end of any sentence, probation, parole, or mandatory supervision. So it's not from the disposition date like most of the expungement law was, the regular expungement law was. So for most of these convictions that we talked about right here, trespass, CDS possession, paraphernalia, prostitution, theft, all of those have a 10-year waiting period. Assault second and common law battery crimes labeled as domestically related have a 15-year waiting period, all from the end of any sentence or probation. Now, what is crimes designated as domestically related? My best understanding of this is the state can bring a motion to label a crime as domestically related, and then they have to prove that the victim and the defendant were in some kind of relationship and had something to do with that relationship, the crime. I don't think this happens all that frequently, and I think where it does happen, it's usually in an assault charge anyways. So you're already in that 15-year waiting category as it is. Okay, so here we have somebody who is charged with assault in the second degree. They pled not guilty, but they received a guilty in 2009. So take a look at this, and remember with assault second, it's a 15-year waiting period from the end of any sentence, probation, or any sentence, probation, mandatory supervision, anything like that. So take a second, take a look at this, and if this client sat down in front of you, when would you tell them that this case is eligible for expungement? If you're feeling confident today, you can write it in the chat box or the question box. Okay, we have a guess here, 2021. Close. Or sorry, not quite, we have an answer. 2025, 17 years. All right, so you guys are mostly correct there. So let's go over what the answer is. So this person was convicted on November of 2009, but if we take a look down here below, we'll see they received 2 years of probation, 1 year of probation with an end date of 2010. So it's 15 years from the end of the probation date, not the disposition date. And so it'd be 15 years from then, which means it'll become eligible August 9th, 2025. There we go. All right, so most of you got that right. So it's important for these Justice Reinvestment Act convictions to make sure you look at whether or not they had any probation or jail time attached to it. Okay, so subsequent convictions. This is what we talked about with probation before judgment. Well, it applies to this new long-term waiting period convictions as well. So you cannot have a subsequent conviction during that waiting period unless that subsequent conviction is also eligible for expungement. And that waiting period is not the 15 years or the 10 years, it's the 10 or 15 years plus any probation or jail time. So like in our case before here, the waiting period that they can't have had a subsequent conviction for, it starts from 2009. So it'd be basically from the disposition date plus 16 years almost. So it's whatever the waiting time is, 15 or 10 years, plus whatever probation time. Okay, there's a question here. So then suspended terms do not count for determining when the waiting period starts. That's correct. So while this person had 2 years suspended, they only had less than a year of probation. And so, if this person had screwed up, they could have gotten up to 2 years in prison, but their probation wasn't actually 2 years. And here's another question. What happens when deal with mandatory release date in a given sentence? What happens when the deal with a mandatory release date in a given sentence? It would be whenever they officially end their sentence, if there's no probation afterward, that's when the 15 or 10 years would start ticking. But for subsequent conviction purposes, they couldn't have gotten a subsequent conviction while they were in jail or on probation, plus 10 or 15 years after that, depending on what the crime is. Does the waiting period start at the incident date or the disposition date? For all intents and purposes, it starts from the disposition date. Well, for the subsequent conviction part, it starts from the disposition date. So, for instance, the 10 or 15-year waiting period for this assault second charge, the 15 years would start ticking not at the disposition date, but from the end of the probation date, 2010. Now, if you're looking to see whether or not there's a subsequent conviction that might prohibit this from being expunged, you have to start looking for the subsequent conviction from the disposition date. And then you have to start looking for whether they have a conviction at any point between the disposition date and the end of their probation date or end of their sentence, plus the 15 years after that. And I have some examples here that might make it a little bit clearer. So here we have somebody who was charged with assault second in 2009. It looks like the same person. And it looks like 5 years later, they received a conviction on robbery with a deadly weapon. This assault second degree conviction is now locked in. They cannot get it expunged, right? Robbery is not an eligible conviction, right? It's going to be probably a felony. And so it is not eligible for expungement. So it locks in this assault second. It is a subsequent conviction within the waiting period, which in this case would be 15 years plus the almost 1 year of probation. So let's take another look here. Here we have somebody who was charged with theft less than $1,000. It's a misdemeanor. It makes it really nice. Some counties on case search will just have the charge right here. It'll say charge class misdemeanor. Usually if it says theft less than any amount, it's going to be a misdemeanor. And this has a probation end date of 2011. So it looks like they got 1 year probation. Okay, but then it looks like this person picked up an assault second in 2016, maybe 5, 6 years later. So now in this situation, both of these convictions are eligible. Misdemeanor theft is an eligible conviction, and assault in the second degree is an eligible conviction. So how does this work out? Well, you can't get the theft charge. Now that there's a subsequent conviction for this theft charge, you can only get this expunged when you can get the subsequent conviction expunged. So if we take a look, this assault second degree conviction will become eligible in 2033. So only when this subsequent conviction becomes eligible can we then go back and expunge this other eligible conviction. And so unfortunately what that means for this person is the theft charge won't become eligible until the subsequent conviction becomes eligible, which is in 2033. So when you're dealing with convictions, you have to kind of slow down a little bit and really keep track of your timelines and what other convictions they have on their record. Okay, are there any questions about that before I move on to some other pieces of expungement law? Can you file for expungement for both charges at the same time? Yes, you can. Technically, it would go on 2 separate forms, but you'd have to wait until both are eligible in this situation. Okay, so victim notification is an interesting new provision added to the Justice Reinvestment Act. Now, victim notification here that I'll explain only applies to the kind of the long waiting period convictions, what was added under the Justice Reinvestment Act. So that's convictions you have to wait at least 10 years to expunge. So what the statute added was the victim of the crime is notified and has a chance to offer additional information relevant to the expungement petition. What this means in practice, we're not entirely certain, but in theory, if it's some kind of assault conviction or something where the defendant doesn't want anything to do with the client or with the victim ever again, it is a potential that they might object and there might be a hearing and if the victim is doesn't feel like the expungement is justified, can explain that to the judge. And unlike regular expungement law, where it's usually pretty black and white and the judge doesn't have a whole lot of discretion, the new law adds in judicial discretion for these long wait period convictions. So if the state or the victim objects to the expungement, the court holds a hearing, and the judge has to now find two things. Now, this doesn't apply to the regular expungement, null pros, not guilty, things like that, only these long waiting period convictions. The judge has to find that the person is not a risk to public safety and that an expungement would be in the interest of justice. If the judge finds both of these and that it's otherwise eligible for expungement, then they go ahead and expunge it. What this potentially means in practice is you might want to be prepared if your client has a lengthy record or something that would make them kind of potentially a risk to judicial discretion, to have some other arguments ready, right? Are they in a workforce development group? Are they have they been convicted of anything or charged with anything in the last 10 years? Potentially be ready to respond and convince the judge that they're not a risk to public safety. Okay, so there's a few other procedural things here I want to cover. The unit rule. So far, all of our examples have been if there's only one disposition or one charge and one disposition in a case, right? But of course, that's not how reality works. Sometimes people are charged with two charges and receive a guilty in one and a not guilty in another, or all ranges of dispositions. So how does it work if there's multiple dispositions in one case? Well, unfortunately, not well for our clients. If one charge in a case cannot be expunged, then the case as a whole cannot be expunged. All the charges from a particular case, now the law technically says from an incident. Usually this is all wrapped up into one case, but sometimes the state will split it into multiple cases, but it's all from the same incident is what the law claims. So if you can't expunge every charge arising out of a particular incident, then you can't expunge any of the charges arising out of that incident. So if you were found not guilty on a whole bunch of charges and guilty on one, you're out of luck, unless that conviction is eligible. So let's take a look at what this looks like. Here we have somebody who was charged with burglary in the first degree, theft, felony theft, both of which were dismissed, and then another felony theft charge, which they were found guilty on. So in this first case, this case is locked in. It's a felony theft charge because we can tell it's felony because it says 500 plus value. And so that's what the felony cutoff limit must have been in 2009. So even though they beat the charge on burglary and theft, it was dismissed for whatever reason, the first theft charge, they cannot get those charges expunged but keep the other one. It's all or nothing. And this is unfortunate because burglary in the first degree is a serious charge, and as we probably all know too well, most employers aren't going to look past and see what dismissed is and try to give them the benefit of the doubt. It's just going to hold it against them. So unfortunately, this first burglary case cannot be expunged. So here we have another case where somebody was charged with intoxicated public disturbance. They received a not guilty in 2017, and they were charged with disorderly conduct, and they received a stet disposition in 2017. So this case, a stet charge is usually eligible, but you have to wait 3 years. This case will become eligible in 2020, but it's not eligible right now. And so unfortunately, you can't get the not guilty expunged early and then go back 3 years and expunge the stet charge. Either all the charges are eligible at that time or none of them are. All right, pending criminal proceedings. So a client cannot have a pending criminal proceeding. If they do, you can't file for expungement in anything. Even if they have 100 cases from 100 years ago that are all perfectly eligible for expungement, regardless of what happens in whatever pending case they have coming up, it doesn't matter. If they have a pending criminal proceeding, they have to finish that, whether they beat it or win it or lose it, before filing for expungement in any case. Now, the courts have said that probation and parole on a conviction does not count as a pending criminal proceeding. So if they're found guilty on something and they're now on probation, that's not pending. They were found guilty, that's over. There is a little bit of gray area here, whether the first year of a stet disposition counts as pending criminal proceeding, and then whether or not you have active probation on a probation before judgment can sometimes be pending criminal proceedings. I find that the state rarely objects to those, so I put it in there, but usually I think you're okay. So traffic, unfortunately, is very confusing. Major traffic offenses follow the same expungement rules we just talked about. And major traffic offenses counts as those which carried the potential for incarceration. Not necessarily that it was likely, but that in the statute, the judge had the ability to sentence the defendant to some kind of jail time. Those are major traffic offenses. They include things like driving on a suspended license, DUI, vehicular manslaughter, things like that. All of those follow the same expungement law we just talked about. If it's a not guilty, they can get expunged. If it's a conviction, odds are they can't unless it's on that list of eligible convictions. Minor traffic offenses follow a totally separate MVA expungement law. Now, I will say that the MVA expungement law has also changed on October 1st, and now a lot more cases will automatically come off. They have longer waiting periods depending on if you've ever had a suspended license or things like that, but at this point, minor traffic offenses will usually come off at some point, so long as enough time has passed since your last moving violation, and that depends on a number of factors. Now, what about cases that include both a major and a minor traffic offense? So this goes against the unit rule that I just talked about, where you can't expunge individual charges. If somebody gets pulled over and let's say they get a DUI and a broken taillight charge, they go to court, they beat the DUI, they get not guilty on the DUI, but they pay the broken taillight charge, which results in a guilty, because when you pay a ticket, you get a guilty. That minor traffic offense where you receive the guilty will not block an otherwise eligible case for expungement. So in that situation, you could still get the DUI expunged because you received a not guilty. It's hard to understand, and until you look at a case, it'll be difficult to truly grasp it. So if you're confused, it's a confusing area. All you have to do basically is, if you see a traffic stop, go through each one of the traffic cases. If it's a minor traffic offense, you can just ignore it. It won't affect the case either way, whether it's guilty or not guilty. If it's a major traffic offense, then you have to do the exact same analysis that we just did here. Now, unfortunately, on case search, traffic offenses are broken in. Each charge gets its own offense. So let's say somebody's charged with DUI and DWI. Those would appear as two separate cases on case search. They would look related because they'd each be incremented by one, but it would still show up as two different cases. Now, under the unit rule, it's from the same incident, even though it's in different cases. And so you'd have to open up both of those, make sure they're both eligible, and then file for both of them. Okay, so I've included a list of all of the incarcerable traffic offenses as a handout. You can basically just match up the statute to the case number to see if it's eligible. The most common one we see is driving on a suspended license, which is technically an incarcerable traffic offense, therefore a major traffic offense. Okay, so we're going to go over two practice clients here. Okay, we have client number one comes into our office, and they have two cases. Case number one is an assault second that was null prost, and a theft less than $1,000, which indicates a misdemeanor theft. They received a guilty in 2014. And then on their second case, they have theft $10,000 to $100,000, which indicates that it's a felony. That was null prost, and a motor vehicle unlawful taking that was null prost in 2017. So I'll give people a second just to review this and kind of go through the notes and see what they would advise this client. Are both cases eligible? Are neither of them eligible? Will some become eligible? So go ahead and take a second to look at this, and then go ahead and write your prediction in the chat box or the question box. And if you're confused or about something, you're more than welcome to ask questions about this as well. Okay, we have a couple of people who have guessed here. So I'm going to go ahead and get started. So I have a couple of guesses here. So let's go over this one case at a time, because that's usually how you want to approach an expungement client, is just one case at a time, go through one charge at a time. Don't try to get too overwhelmed with all of their cases that they might have. If we look at case number 1, assault second, they received a null process in 2014. Null processes are always eligible, so that charge is good. We don't know if we can expunge it yet, because we have to take a look at all the other charges, but that one's not going to hold anything back. Null process, if you see a null process, you can, almost write a check mark and go on to the next one. So then we see this theft less than 1,000. That's a misdemeanor theft, and they received a guilty in 2014. Now, luckily, misdemeanor theft is on the list of eligible convictions, so it's eligible for expungement. However, it has a 10-year waiting period. So we'll go from the disposition date here, because I don't actually see a probation end date, and so it's from 2014. And so I would say that, it looks like they did a year in jail. So that's why there's no probation end date. Year in jail, none of it was suspended. And so they'll get out presumably in November of 2015, and that's when the 10 years will start counting. And so this case will become eligible November 19th, because technically it's a year and 1 day, November 19th, 2025. So very good job, Janet. So now we move on to case number 2, and now we're not entirely certain about whether this is eligible yet, because we have to see if there's any subsequent convictions. Now we can quickly just glance over, there's only one other case on this client's record, it's all null process, so we know that there's no subsequent conviction. So case number 1 is eligible. Now we take a look at case number 2. They received a felony theft conviction, a felony theft charge that was null processed this year, and looks like some kind of car joyriding charge that was also null processed in 2017. So case number 2 is also eligible. If you see a null process, that's great, right? Most dispositions are null process. Null process can be expunged immediately. Both charges were null processed in 2017. So case number 2 is eligible for expungement, but because it's within 3 years, right? I mean, this was expunged this was concluded just a few months ago. So we're within that 3-year window, so they have to give up their right to sue. So if this client came into my office, I said, okay, we're going to file for case number 2 today and get that expunged, and you're going to have to give up your rights to sue. And for case number 1, here's my card. Give me a call in 2025. Any confusion as to why any of that is? Okay, good work, everybody. We have one more client here, example client, that I have some forms and kind of filing procedural stuff to go over. And we're going to go through this one fairly quickly here. So just kind of, because we're slowly running out of time, just shout out your best answers in the question or the chat box. So this client has 3 cases, a conviction on marijuana possession, a conviction on open container from 2009, attempted CDS manufacturing conviction, and a possession of something other than marijuana that was null processed. And in case number 3, some issue of false document, which was steaded, and another issued false document, which was steaded. I guess they issued 2 false documents, both in 2016. So I'll give just a minute for people to look over that and kind of give their prediction. And if you're only certain about one of the cases or 2 of the cases, but not the other one, you're more than welcome to just say, this is what I think about case 1. I'm not sure about case 3. Okay, so let's go over this client here. Okay, so now this is probably a more complicated case than you would actually see in real life. This is really meant to bring out a lot of the kind of nuances to expungement. So let's go case by case. So we see this case one. Looks like they were convicted of possession of marijuana and open container. Now, possession of marijuana is one of the low or short waiting period convictions that are eligible. Open container is a nuisance crime, which is the other category of short waiting period convictions that are eligible. So both of these are eligible. Possession of marijuana carries a 4-year waiting period, and nuisance crime, which is open container, carries a 3-year waiting period. So either way, we're both outside both of those windows. And it's important to remember that possession of marijuana and open or nuisance crimes don't have a subsequent conviction rule. So case number one is eligible for expungement. So now we move on to case number two. We see there's a conviction on attempted CDS manufacturing and distribution. We can stop the analysis of the case right then and there. It doesn't matter what the second charge is because they were convicted of something that isn't on that list of eligible convictions. This is not marijuana possession. It's not a nuisance crime. It's not on that list of new Justice Reinvestment Act convictions that are eligible, right? Because it's not possession. It's attempted CDS manufacturing and distribution. So unfortunately, case number two is not eligible and will never become eligible unless they change the law. So then we go to case number three, issuing of a false document to STET. They received a STET on both charges. And we look back at our notes, we know that STET is an eligible case. However, there's a 3-year waiting period, so I think a lot of people got this. It's from 2016, so you have to wait 3 years. So in 2019, case number three would become eligible for expungement. And if you struggle with these, don't worry about it. If you come to the clinics, I'm at every expungement clinic, and my whole job there is to go around answering questions for attorneys when these kind of come up. If you take a case, I'm more than happy to answer emails about whether or not something's eligible or not. Give me hypotheticals. I can review documents for you, whatever you need help with. And the learning curve here is a little steep, but it's very short. I find most attorneys, after 1 or 2 clients, it clicks and they're able to cruise through them. So now let's talk about the forms. We're running out of time here, so I'm going to go through them fairly quickly. This is a big change from the old law. So if you're familiar with the old expungement law and you came here to learn about the new expungement law, this is part of what you want to listen to. So they got rid of the old expungement petition form. There's now 2 forms. There's one form if the case does not contain a single conviction, and now there's one form if the case contained a single conviction. And so the principle is still pretty much similar. You go through, you check the box that correlates to the legal reason for why it's eligible, right? A null pros was entered, and either 3 years have passed or the client has given up the right to sue, or it's a conviction listed under the JRA convictions and more than 10 years have passed, something like that. So you check the right box. You can check multiple boxes as well. And then the top information is all objective information about the case number, name, what they were charged with, things like that. But the old form is no longer in use. Can we access the handouts after the webinar? I'm not sure. I think you have to probably download them, but I'm going to send them around in an email after this, so no worries. So the fee waiver, if you're used to the fee waiver where you had to file it for everything, that has now changed as well. If you're filing for expungement in a case that does not have a single conviction, there is no longer a filing fee, so you don't have to file this in addition. If you're filing for expungement of a conviction, that's one of the eligible convictions, that $30 court filing fee still applies. However, if you are volunteering with a group like Maryland Volunteer Lawyer Service, we screen all our clients for income, and we can get that fee automatically waived by filling out this additional form. This is the waiver and release. It's required if you have one of those good dispositions and you're filing within the first 3 years since the disposition date. It does not have to be notarized. It kind of looks like it does. And an attorney can sign as the witness, and the client signs the signature on the bottom right. If you are part of the Office of the Attorney General, you should not advise clients as to whether or not you should sign this, and you should not act as the witness. Just call me over, I'll be the witness, and I'll explain exactly what they're signing. If you don't sue the state for a living, I have no idea what goes into a good lawsuit against the state. So I would not get into the trap of listening to facts and trying to decide whether or not they should waive their rights. Simply, this is what you're giving up. If you would like to pursue that avenue, you need to go talk to an attorney that does that before signing and filing for this expungement. You can always go back and file for expungement. You can't go back and have this revoke this waiver of liability. So try not to get trapped into the listening to the facts and giving legal advice as to whether or not they have a good case or not against the state. How to file. You should always make or scan a copy of the petitions before filing. The courts lose petitions all the time, and the last thing you want to do is 6 months from now call the court and have them say, what expungement petition. So always make sure you have a copy. You file 3 copies in the original with the court. You can mail them into the court. You don't have to deliver them in person. If you enclose a pre-stamped envelope with your address on it, the court will send you back a courtesy copy that's stamped in case they do lose it or something, and you can show proof that the court actually did receive it, and they'll speed you through the process. So the time frame. The state's attorney has about 30 days from when they receive the petition to object. So if you don't get an objection in the first about 45 days, it's usually a good sign. It means that odds are it'll go through. Without an objection, it takes between 4 and 6 months, depending on what county and what court level. Baltimore City District Court is inundated with these, so they have one of the slower times. I find most circuit courts to be quicker. If there is an objection filed for some reason, and it happens, right? If you're in a clinic, you're going fast, you make a mistake, it's very easy to correct. If you filed something and you realize that you had the time frame wrongs or something, and the state objects, you just file a motion to withdraw the petition, and the court will cancel the hearing. I have templates for all of these motions, and I'm more than happy to give them to you and help you file them. And it's very simple process. You want to try to get on it as quick as possible, because you don't, the motion still has to go to the court for the judge to rule on, for them to cancel the hearing. But I've never had a judge not grant a motion to withdraw the petition. Closing out, you just want to check all the cases on Judiciary Case Search to make sure that they've been removed. It's also good practice to make sure that the orders have all come in, that you have a record of it, and then you simply write a closing letter to the client explaining that the cases you have filed have been removed. In theory, the client and you should get a copy of everything the court sends. And so they get a copy of the order, they get a copy of all these certifications that are sent afterwards. So in theory, you don't have to send them a copy of that, but it's good to keep on record just in case. I've seen every possible expungement problem that exists, and I've been able to solve every single one. Expungement is a very forgiving area of law. It's almost impossible, if not impossible, to permanently mess up any kind of expungement petition. The worst thing that happens is you just refile if you messed up, or you can file later. There's no requirement that you file everything that's eligible at the same time. So it's a very forgiving area of law. It's not like a child custody case or something where it has serious ramifications. Okay, really quickly here, MD Expungement is a program that we use to automate the expungement process. So I'm going to show you how it works here really quick. So here we have a case. It's a assault second that received a stet in 1997. This is perfectly eligible for expungement, right? It's been more than 3 years. So to expunge this, what we can do is we can copy the case number. And then if we go to a website called mdexpungement.com, what we can do is we can type in the case number right here, click expunge. It will tell you that it's likely eligible for expungement, right? It's a stet more than 3 years. It follows the same process. We click next. Then you can print out the expungement petition required for expungement. So it'll take all the information from case search. It uses a web scraper. and then we'll populate the form with all the correct information and check the right boxes. So check the box as that was entered. So really all you have to do is print and have the client sign it. And so this acts as a very good double check. Although, as an attorney, you should always make sure everything looks good, on your end. But this helps to speed up the process a lot. MD Expungement has, since this has come out, they've produced a new tool called a Chrome extension. So if you use the Chrome browser, you can actually add an extension to your Chrome browser that will help you expunge cases directly in Case Search. So let's say you're taking a look at this case in Case Search, you want to get it expunged. If you have the Chrome extension as this little blue button that it adds to your Chrome browser, you can click that and it will tell you that it's likely eligible. You can click Add Case. You could keep doing this for as many cases on Case Search as they have, and then click Print. And it will print all the forms you needed. If this was like a null pros case within the first 3 years, it would populate the waiver if that was needed. Or if it's a conviction, it would populate the filing fees. And so it's fairly good at being able to determine which forms you need. It sometimes gets a little caught up on the new Justice Reinvestment Act convictions. And so it'll know you're trying to print out the form for a conviction, but you might have to check the right box. So always double check the paperwork, but this helps to speed up the process a lot. And this is mdexpungement.com. It's all free, but if you want to learn more, it's a good place to get started. Okay, we're nearing the end here. Okay, tips for using judiciary case search. This is, using case search is a very kind of work of art, and it's something you have to get used to. If it says forwarded to circuit court and there's no disposition for the charges, you need to find the circuit court version, They prayed a jury trial, something like that, and what the outcome is in the circuit court case, not the district court case. If the circuit court case is eligible for expungement, you can file for the circuit court case only, and they will automatically expunge the district court case. Do not add a middle name or initial when you're searching for a client. They will automatically rule that out. So if you search John M. Smith, anytime when the clerk forgot to add the middle initial or just didn't do it as a policy, it will no longer show up. So don't add a middle initial. You want to keep the defendant, change the party type to defendant, all case types, all districts, all counties. Okay, volunteering here. There's a couple of ways to volunteer. The first is clinics. So these, we usually have one a month or one every 2 months, depending. And there's usually a set time. So we'll partner with a church or a community center, and for 4 hours, we will be at the clinic to expunge anybody's record who shows up. And these can be very popular with clients. And so we just have one at a time. We sit them down, we go through their record on case search, we expunge all the cases we can find, and we move on to the next client. It's a great way to just really dive straight in and get up to speed. I'm at every clinic, so if you run into problems, something is confusing, just I'll come over and I'll help you out, and I'll take all of the kind of complicated clients. If you don't have time for a clinic, there's also the ability to take a single client. So we have people call all the time who need expungement help. If you would like one of these clients, what we do is we pre-screen them so we know they have at least something eligible on their record, and then you can find time on your own with the client to meet at a Starbucks, or you can even do it all through the mail, and we'll give you the client's name, you look up their record, you print all their petitions, you either mail it to them or you can meet with them at a Starbucks or something to have them sign all the petitions. So if you like taking the really kind of slow, methodical, make sure you cross all your T's, this is a great way to do that. And then finally, the third way is to take pre-completed petitions. So we have some attorneys who work for government organizations who can't actually be the attorney of record for an expungement. So they will review, they'll sit with the client, go over case search, expunge everything they can, print out all the petitions, have the client sign it, but they can't actually sign it or file it under their own name. So we need attorneys just to take those petitions, do a double check, review that they got everything correct, and then go ahead and sign their name to it and file with the courts. So this could be a great way to kind of slowly dip your toe in, because some other attorney has already done a majority of the work. And malpractice insurance applies to all attorneys throughout the process, at the clinic, for the life of the client. So before I conclude here, we've created a couple of training videos. Now, I'm a big technologist, right? I'm the IT director here. And so in an effort to expand the ways that we are training people, we've created a number of virtual reality training videos, some of which are an expungement, that are mock hearings for common expungement hearings that take place. So we didn't go over good cause hearings, but that's a factor in the law. And so if you're curious as to what this looks like, they're all available for free on YouTube. And you can go to the link bit.ly/BR lawyer trainings, or you can just search Maryland expungement training. There's not too many of them. And what makes this cool is you can actually load it up on your phone, pop it into one of these cheap $10 VR headsets, and be transported into the courtroom to watch this hearing take place. We filmed it with a special camera that captures all 360 around it. And so if you're curious in it, take a look. I think it's kind of the next step of training attorneys and law students, and in the future, maybe even clients, on how to represent people in courtrooms. So that concludes it. Thank you. I know I went a little bit over here. I try to keep it at an hour, but thank you for holding on, everybody who did. If you have any questions, feel free to email me, to give me a call. I'm going to send around an email later today with a link to this presentation, copies of all the handouts, and then some useful links that I talked about here today. And if you have any questions, reach out to me. If you'd like to take a case, there'll be information in the email that goes around. Basically, you contact Michelle Swift, who's our pro bono manager, and she will be able to place a client with you and give you more information on the whole process. But that's it. I'm going to stick around for a few more minutes if anybody else has any questions. But other than that, that's the end of the training. Thank you so much.